Imagine a high-profile convict, newly released after serving their sentence. They change their name and relocate it because their life is under active threat from vigilantes. But their attempt to vanish fails. They are photographed emerging from a walk-in HIV and STD clinic in London. A national newspaper, the Daily Messenger, acquires the photograph and the convict's new location, and they plan to publish both on tomorrow's front page. This scenario creates an immediate legal collision between three distinct rights under the European Convention on Human Rights: the convict's right to life under Article 2 and their privacy right under Article 8 directly clash with the press's freedom of expression under Article 10. The European Convention does not contain a strict, universal hierarchy where one right automatically trumps the others. Instead, courts must determine priority on a case-by-case basis, using specific analytical frameworks. To understand how judges resolve these conflicts, we have to examine three distinct legal battlegrounds: clashes between absolute and qualified rights, the tension between a fair trial and free expression, and the complex proportionality test used when privacy and free expression collide. Applying the wrong judicial test to the wrong category of conflict is the most frequent reason law students fail problem questions on this topic. You must recognize which battleground you are standing on. The first rule is straightforward. When an absolute right, like the Article 2 right to life, conflicts with a qualified right, like Article 10 freedom of expression, the absolute right prevails. This principle is illustrated by the 2001 case of Venables and Thompson versus News Group newspapers. The court had to decide whether to grant an injunction to permanently anonymize two notorious child murderers upon their release from detention, protecting them from the intense public hostility. The court found that publishing their new identities would put their lives in immediate danger. Because it involved a threat to life and limb, Article 2 was automatically engaged. Since Article 2 is absolute, it instantly defeated the newspaper's Article 10 rights, granting the injunction. In 2005, the High Court extended this logic to adult offenders in Carr v. News Group, granting an indefinite order protecting a new identity to prevent severe psychological harm and physical injury. While absolute rights always win, you must cite the Supreme Court's ruling in A v. BBC. The court noted the crucial role of the media in a democracy, meaning any interference with their Article 10 rights must be no greater than is strictly necessary. Our second battleground moves away from common law balancing. When media coverage threatens the Article 6 right to a fair trial, the law relies on a strict statutory framework to prevent trial by press. This flowchart illustrates the strict liability rule from the Contempt of Court Act 1981. Publishers are liable regardless of intent. Section 2.1 requires a publication addressed to the public. Sections 2.3 and 2.4 require active proceedings. Section 2.2 requires a substantial risk of serious prejudice. But this creates a problem for journalists covering broad social issues. In Attorney General versus English, a newspaper published an article arguing that severely disabled babies were being allowed to die. They published this while a doctor was on trial for the murder of a disabled baby. Does discussing broad public policy topics during a highly relevant active trial trigger strict liability contempt? The flowchart accounts for this via Section 5 of the Act, which protects discussions made in good faith on matters of general public interest. The House of Lords ruled in favor of the newspaper. The article did not mention the doctor's trial specifically. Because the risk of prejudice was merely an incidental consequence of debating a larger policy theme, Section 5 applied, and there was no contempt.
Note carefully that Section 5 is not technically a defense. It stands on equal footing with Section 2.2. It is the prosecution's burden to prove that Section 5 does not apply to the publication. The most complex clashes happen when two qualified rights collide, specifically the Article 8 right to privacy and the Article 10 right to freedom of expression. In principle, there is no clear priority between them. Section 12.4 of the Human Rights Act 1998 requires courts to have particular regard to freedom of expression, designed to stop privacy claims from unduly gagging the press. The defining modern framework for this conflict comes from the 2004 House of Lords case, Campbell v. Mirror Group newspapers. The Daily Mirror published an article confirming supermodel Naomi Campbell was a drug addict. Crucially, they also published the details of her treatment and covert photographs of her leaving a Narcotics Anonymous meeting. This diagram shows Baroness Hale's two-stage test. Stage 1 asks if Article 8 is engaged, requiring the claimant to prove a reasonable expectation of privacy.
If engaged, stage 2 is the balancing exercise, weighing the comparative rights and testing proportionality against the public interest. In Campbell, the court ruled that because she had publicly lied about taking drugs, the press was justified in exposing the addiction. However, publishing her private medical treatment details and the covert photographs was a disproportionate intrusion that could deter her recovery. Article 8 prevailed. When judges conduct this balancing exercise, the decisive factor is usually whether the publication contributes to a genuine debate of general interest. The European Court of Human Rights solidified this in von Hannover v. Germany. Paparazzi photos showing Princess Caroline shopping and riding horses did not contribute to political debate. She exercised no official state function, so her privacy outweighed the media's desire to publish photos of her daily routine. A common error in exam answers is jumping straight into the balancing exercise. You must always establish a reasonable expectation of privacy first, referencing cases like Murray, before you apply the Campbell proportionality test. Let's return to our opening problem: the released convict, the walk-in clinic, and the Daily Messenger's front page. The threat of vigilante justice clearly endangers the convict's life. Applying the rules of Battleground 1, Article 2 is absolute. The newspaper is strictly barred from publishing the convict's new location. As for the clinic photograph, we apply the Battleground 3 framework. The medical nature of a walk-in clinic creates a clear expectation of privacy. Because a private medical visit contributes nothing to a debate of general public interest, Article 8 easily defeats the newspaper's Article 10 rights. Wondering how an individual uses human rights law against a private newspaper rather than the state? It works through horizontal effect. Under Section 6 of the Human Rights Act 1998, the court is a public authority, legally bound to act compatibly with convention rights in private disputes. Historically, courts clumsily forced Article 8 privacy claims into the equitable doctrine of breach of confidence. But jurisprudence has evolved. In modern cases like Vidal-Hall and PJS, courts recognized that squeezing human rights into old property laws was unnecessary, formally developing a distinct, standalone tort of misuse of private information. Success in analyzing ECHR conflicts does not come from arguing morality. It comes from identifying the precise rights engaged, categorizing the conflict into the correct legal battleground, and strictly executing the statutory or common law framework that governs it.